So thank you for joining. Let's see. I can't see these screens, so if something goes awry, just raise your hand and let me know as I walk around. Thank you for joining. Today we're going to talk about IP. Before we even get there, I'd kind of like to gauge the audience a little bit. Like, who feels like they have a fairly decent understanding of what IP is? Few? Seen some of these, like the maybes. Who's willing to admit that they're really not familiar with IP at all? Maybe don't even know what I mean when I say IP yet. Okay, well that's great. It's a good opportunity for learning in here. So IP stands for intellectual property. Sure, it stands for other things. In my world, it's intellectual property. What is intellectual property? It's products of the mind. Every business intersects with IP in one way or another. So if you're involved in business, you have some IP concern even if you don't know it. At the very least, because your business, I presume, has a name, and you have some sort of goodwill that you have, or at least hope that you have associated with your business name. Has anyone here filed a patent application? Or, sorry, been involved with the process of a patent ever? No? Trademark? Oh, one back there? Trademark there? All right. So we have the objectives today. First, we want you to walk out of here knowing a bit more about IP than you knew walking in. At least know what the basic main forms of IP that may involve your business are, why they add value to your business, and most of all, more than anything else, we want everybody in here to at least be aware of some issues to keep an eye out for so you can proactively take steps to avoid inadvertent loss of your rights. There are steps that every business should be taking well before they contact like a patent lawyer like myself or a trademark agent, so that when we have our sit-down meeting, we go, oh, okay, well now there's a problem. So some of these easy steps you can take before you even talk to your lawyer. So why it matters? Like I said, it's an asset. It's a very valuable business asset. In some cases, some businesses' most valuable asset is their IP. It's their trademark. It's their name. Gives you a competitive advantage, particularly in the technological fields. If you ever watch Dragon's Den, there is a reason that people are always being asked, do you have a patent for this? Have you applied for a patent for this? So there are some sort of proprietary rights that you have to bargain with. And tied to that, it gives you leverage in negotiations. So you can protect your market share, protect your reputation, generate income. It's not just an asset that you hold. IP can generate income both by licensing, assigning. You can sell it to other people. You can get royalties. And as I mentioned earlier, you can inadvertently lose these rights if you don't take the proper steps early on. So we're going to talk about some of these pitfalls. Before we get there, I just want to talk about some very basic points about the main types of IP. So patents. This is where I spend the vast majority of my time. Patents protect inventions, which refers to any sort of technological advancement, utilitarian, functional advancement in technology. And we'll go to a legal definition in a minute. But it gives you the right to exclude others from practicing your invention. If you get a patent, usually for 20 years from the time the application was filed, once the patent's granted in a particular country, you can prevent other people from doing that. So invention is any new and useful machine, manufacture, composition of matter, process, or method. This is very broad. When you read that, that's what should be going in your mind. Virtually every kind of utilitarian advancement or an improvement to any of these things. You don't have to invent the wheel. If you invent the wheel with a slightly better rim, great. You can get a patent for that. There are some exclusions. We're not going to go into detail on those, but today I really want you to ask questions. So if you have questions about what might not be patentable, or you want to talk about software and the ins and outs, feel free to ask questions anytime. I'd much rather be answering questions than going through slides. And we'll have some activities to facilitate that as well. But industrial designs, in the US, this is called a design patent. In Canada, it's called an industrial design. So you can think of it as the flip side of the coin to a patent. This protects aesthetic features as opposed to functional. So something that has some sort of aesthetic feature, the design of a bottle, a Coke bottle is a perfect example, shape of an iPhone. These kinds of things can be protected with design. And again, it has a limited term, 10 to 15 years in Canada now. Trademarks protect brands, logos, designs, basically anything that distinguishes your goods and services from your competitors. And there's variations between Canada and the US, but that's the basic idea. Registration is 10 years, but trademarks, unlike patents and designs, you can renew forever as long as you're still using it. So there's a wide array of types of trademarks. We're not going to go through all of these in great detail. Again, unless you have questions, happy to dive into these various examples. Copyright. This is something that even people not involved with business, like from the time you're young, you probably have heard something about copyright, why you can't just copy somebody else's book or poem. But any sort of artistic work or dramatic work, the bar is very, very low. So for example, the phone book, how names and numbers are arranged in a phone book, that will have some copyright attached to it. Copyright is automatic. You don't have to apply for it. You can register your copyright, but you do not have to apply to the government for copyrights, and that's very different from, say, patents.
The R in a circle, that stands for registered?
That's for a registered trademark, yeah. Yeah, the C in the circle is copyright, but again, you don't have to, like, copyright is just automatic. And the bar is extremely low. The term of copyright keeps getting extended over the years. Currently, it's 70 years from the death of the author. It used to be much shorter. Trade secrets. This is something that applies to almost every business. Trade secrets are basically confidential information that has value by the fact that it's secret. So I think the Coke formula is a big example, but there are certain intellectual properties that your company has that you don't want to share, that you want to keep private, and that's trade secrets. Upside never expires as long as it's kept a secret. Downside, if it gets out, well, now there's nothing you can do except maybe rely on contractual obligations and sue somebody. But if the Coke formula got out, they couldn't call it a trade secret anymore. So with that very, very crash course overview, I'm going to turn it over to Kyle.
Fair enough. All right. So today we're going to talk about two areas primarily, being trademarks and patents. And we're going to start out with trademarks. And I really love the talk this morning. Chloe and Steve's talks kind of work perfectly with exactly what I'm here to talk about today. I actually had a section talking about the gator brain, or heuristics, that sort of idea of initial impression. And really when it comes to trademarks, that's what you're protecting. That initial impression that makes someone walk up and grab a Coke as opposed to a no-name brand. Or when they think they need a lawyer, having them call Parlee as opposed to whatever other one they can find in the phone book. Or you need a consultant, you call up Results because you remember you have an association with them. And that's what trademarks really protect, is that reputation that you have in the name that connects the name with thoughts of good quality or other sorts of reputation that you have with that name. And then, of course, we had our other one this morning talking about rockstar branding. And branding is exactly that. It's taking that trademark and attaching thoughts to it, things that you associate either the image of Kiss with the Kiss name, or you think about certain types of songs when you think about AC/DC. Those are the sorts of connections that trademarks are meant to protect and why they have value to your business. So, as a father of young kids, I find that the best way to make anything more interesting is to give people crayons and let them draw. So, we have an activity, and what we're going to do is each of the tables is going to create their own trademarks. Each of you are going to be a construction company, or each table of people, so feel free to add people to your table and spread it around so that you have enough people to do the activity. But come up with a name between your group and design yourself a logo using the tools at your table. And if you have extra time, come up with the logo. Give you about 5 to 10 minutes on the activity, and then we will come back and we will have a discussion about what you guys came up with. All right? All right. So wandering around the room, I saw a whole bunch of really cool logos. Anyone want to talk about the names they come up with or the logos they came up with and what you were intending to get across to the your potential customers with the trademarks?
Not until we get the trademark.
Ah, fair enough. Fair enough. All right. Don't do that. Any motion will get you.
Build it. The 6 of us are starting a company like right after this session. And we're starting with our logo here. So the company's called Build It, and as you can see, we have an in-house designer. There's a little nail and a hammer here for Build It.
Nice. Anyways, our mission is to build homes across North America.
I love it. I love it. All right. Anyone else want to share theirs?
Sure. Or we'll share. So this is us here, Ironwood Construction. So we created a little shovel there for the eye. That's our, what it is. Ironwood Construction. Thank you.
Nice. And Bianca, what's Ironwood meant to refer to? Is that like a place or a...
No, it's because it's a very strong company. So
Eh?
yeah,
Okay.
that's the idea.
I like it.
And they can deliver a good product and on time because we're efficient.
Nice. All right. Well, I see a couple other people wanting to. Do you want to go first, Deanna?
Yeah, this is ours. You probably can't see it because I wasn't expecting to present to a bar group. It says simple, but it's spelled without the vowels because that wouldn't be simple. And our slogan is make it easy. And the logo that we designed, I suggested we do the favicon because that's the logo of the future because the square fits in every location on all social media platforms. So maybe we're the building company for the future, for the next generation.
Oh,
Yes, and we did color theory. So we chose S, the blue, because blue is trustworthy and kind, and M in orange because orange is fun, and P is green because we're environmental, and L is in purple because we're passionate.
I love it. Very nice. Look at all the marketing psychology going over here. All right. And Jessa, did you want to share yours as well?
Sure. We are super creative, and so we combined the three companies at this table.
We have no idea what we do.
Yeah, that's what we do. So Pontum, Kerr, and Tomco made Poncurco. And we met in the mountains, so there's like a mountain feature in our lovely triangle, and we're gonna make great houses.
Great favicon.
I love it. Very nice.
Right, so.
All right. So now that we've looked at our logos and we've designed some logos, let's take a look and see if they're protectable. So this is the spectrum of trademark strength. From one side in generic to the other side of fanciful. So generic trademarks or descriptive trademarks, these have limited protection to no protection. These are the ones where you're describing your products or you're saying something about your products. So if you named yourself the best software company, that's probably not something that you're going to get a trademark registered for. If you call yourself the local liquor store, it's very descriptive of what you provide and where you're located, that sort of thing. So anything where you're describing your products or using generic words that are used commonly within your industry, those elements are not going to be protectable. On the other end of the scale, we have our fanciful names. These are ones where the name doesn't refer to anything aside from the company. So it's a made-up word. Exxon only has meaning in relation to ExxonMobil. Kodak only has meaning in relation to the Kodak company. Xerox, same sort of thing. These are made-up words, or I guess now Xerox actually does have a meaning outside of that, but when it was created, it didn't. So all of these are made-up words, and these are the strongest type of trademarks because they don't have any other connotations to them. They only relate to your business, your products. So they have the highest level of protection. Next level down from fanciful is arbitrary. And to understand this one, trademarks are about the context of your services, the context of your products. So you can think about it in terms of, on a Google search, what's going to come up when you search for construction companies? Or on a store shelf, what is your product going to be next to on the store shelf if they're putting things next to other things that are similar in nature? So for arbitrary ones, this is one where you've taken a concept and taken it entirely outside of its context and applied it to a different industry or a different area. Apple is a perfect example. If you were starting an Apple company and you called it Apple, you could not trademark that. That's not protectable against anyone. That would be descriptive or generic. But there's no apples in this computer up here. When you apply the concept of a fruit apple to a computer, that is taken outside of its context, and so it becomes arbitrary, and therefore it has a level of protection that is much higher than the normal descriptive or generic terms. Yes?
How does that apply if you just, if it, let's say it's still apple, but you change the way it's, like, let's say you take off a P, or you add an L, or whatever. The word itself is slightly different, but it's not the generic word.
Yeah, so you mean in terms of how would that apply to, like, whether it counts as generic or descriptive? Yeah, because I did see a couple of those around where it was an existing word that was taken and the lettering was changed, that sort of thing. So when we're looking at this, the level of protection that you have, if you take a word like simple over here, simple is a concept that makes sense, that would be descriptive of your product. We provide simple products, they're easy to understand, that sort of thing. If you take it and you change the way that it is written, then you'll have protection for the way that that is written. You'll have protection for SIMPL or however you've phrased it. But if a competitor comes along and they call themselves simple spelled in the normal way, you can't stop them from using that because that's a generic concept, but you can stop them from using your version of it. And with a lot of these names that do have more straightforward names that can't be generally protected, so like McDonald's, for instance, if you have the last name McDonald's, you're allowed to use your name in association with a restaurant. What you can't do is you can't put the Golden Arches next to your name. You can't use Ronald McDonald. The other elements of the brand are often the ones that will differentiate your product and allow you to be able to have a level of protection that the word itself wouldn't have necessarily provided. So for like SIMPL or for Build It, that would be something I'd probably put in the next category here, which is suggestive. It's not in the way that you would normally say build it or in the way that you would normally word simple. It is suggestive of a concept. The same way that Microsoft is suggestive of a concept of building software, or Citibank is suggestive of the idea that you have a bank in the city. Those concepts by themselves aren't protectable, but when you mash them together, you can have a name that is protectable. And so that's our other category here, is the suggestive ones. So I did kind of cover a couple of these ones. Anyone here who would look at their trademark that they came up with, their name of their company, as being a fanciful name, made up name? So that concept would tend towards the middle of the spectrum. That would be suggestive, and a lot of times they'll look at what you're actually referring to. So if you just use your initials and you market yourself based on those initials. So like say RBC, for instance. RBC is a protected trademark of Royal Bank of Canada. And it has a level of protection for that name. But the level of protection that you have will be a little less than other names. And knowing what it stands for, Royal Bank of Canada, also plays into the way that people view the marks. One of the things that trademarks is about is it's much more of an art than a science. When you're talking about whether one mark infringes with another or one is protectable and another isn't, a lot of this is gray area. There are some black and whites, there are some, and there's a big area of gray when it comes to these areas. And I'll get into some of that in a few minutes. But yes, initials would generally be protectable, but more towards the area of the middle of the spectrum as opposed to being the higher end or the lower end. I think for yours was kind of a made-up name that was formed by combining a bunch of different companies, right? That is one that arguably would go to the fanciful end. And again, these aren't hard and fast rules. It's still kind of to give you an idea about where things fall on the spectrum, but that was probably one that would fall into that area. Ironwood, which we had over there, would be a good example of a suggestive one. You're suggesting the idea of iron and wood combining, and obviously if you're a construction company, you probably use wood at least, probably iron as well. I don't know enough about construction to say for sure, but I'm sure you do use that. So that would be a suggestive one, and it's also suggesting certain concepts along with it. So that would be a level of protection there. I did have ChatGPT do a couple other ones up for me. just in case I didn't have some good ones to talk about, but I actually did have some great ones to talk about. Solid foundations at the top is a good example of just a straight descriptive mark or a generic mark. Foundations are something that you obviously build in construction. You want your products to be solid. That's indicative of the quality of your product. And so that's something that probably would not be protectable. And I actually did a trademark search on that one. Couldn't find solid foundations. It's probably because there's no one who's tried to register it because it's not registerable, or they tried and it was turned down. Some of the other ones on here, blue sky builders, that's more of a suggestive concept, be around the middle of that range. Keystone construction, similar sort of concept, evergreen, summit. You're taking different ideas from other areas, so they'd fall kind of into that suggestive or arbitrary category, would be protectable. And for some of these ones, they actually do have Blue Sky, for instance. I went and they did a trademark search of that, and there's a whole bunch of companies named Blue Sky, but a lot of them are cosmetics, toys. There's a credit card company, a beekeeping equipment company. I love that concept. And they called themselves Blue Sky. If you wanted to create a construction company called Blue Sky Construction, you could. It would not overlap with any of those other ones. It wouldn't come up on the same Google searches, wouldn't be on the same store shelf. It's distinct enough and it's arbitrary enough that you would be able to register that concept. Now, a lot of these concepts also apply to logos. And it's important when we're looking at logos and also for word marks as well, the confusion tests. So if we're looking at whether or not one mark infringes on another, so if someone's got a mark in the marketplace and someone else tries to create a similar mark, where do you cross the line into infringement? The test is whether the casual consumer who is somewhat in a hurry would be confused as to the source of those products, the source of those goods. So when we look at these logos, it's important to understand a couple of different concepts here. So I've got the logos at the top, and I was a little surprised actually, because when I asked Midjourney, which is an AI generative tool, to come up with logos, they seem to think that for a construction company, you should have a dude with a hard hat there. That was their concept. No one else in this room came up with that concept, but this is what Midjourney thinks that should look like. They did also come up with the buildings in the background. I know I saw some of those buildings in the background of some of the logos. So when you look at these logos, there's certain elements of that cannot be protected by themselves. The concept of a guy with a hard hat is not a protectable concept that you can have in your logo. So you can have a logo with a guy in a hard hat, but that element by itself will not mean that someone else is infringing it. So if we look at these examples here, the top two, whichever one is in the marketplace first, I think the other one would be infringing. The reason why is not just because they have the dude in the hard hat, but because they have a lot of other elements as well. And it's the total picture we look at. So they've got the guy in the hard hat, they've got the buildings behind, but they also have the same coloring, same color scheme. They've got the circular logo with the black background behind it. There's a lot of elements where if you just took a quick look at these logos and you were somewhat in a hurry, you could be confused as to whether or not you were looking at the logo for company A or company B. The two on the bottom though, the one with the sort of lighter coloring, I would say that one is not infringing. And that's because the only element that's overlapping with the top two logos is the guy in the hard hat, which as an individual element is not distinct enough or original enough to have a level of protection. If you had, for instance, Twitter, their logo is a bird. And that one is arbitrary in the sense that social media isn't about birds. It's not a bird company, but it's something that's taken out of that element. So if the central element of Twitter's logo is a bird and you have another social media company and you want to put a bird on it, that's going to be a problem. But if it's two construction companies and the element that's overlapping between the two of them is something that is very common, then that's something where you probably can't get protection for the guy in the hard hat. So if it's a more original element as well, once you get to the fanciful thing and you're coming up with like, a magical animal that no one's ever heard of before and that's your logo, then someone else coming up with something that is remotely similar to that, it's going to have a higher level of protection because it is fanciful, it is very different. Another thing to understand is the difference between registered and unregistered trademarks. So I think everyone kind of gets the idea of what a registered mark is. You file with the trademark office, they say yay or nay, you got to register, you got protection. Unregistered marks are the ones that people often don't understand. So it's a common law concept where it's not about having specific protection for something. It's about someone not being able to pass off their product as yours. It's actually a tort of negligence. And if someone else has a product that they are trying to pass off as your product, and their mark is similar enough to yours, even if yours is not registered, if theirs is similar enough to yours, you can sue them for passing off, and you can get the same sort of protection that you can get from the court for registered marks. So you can get an injunction to say that they can't use that name anymore, they can't use that logo anymore, whatever it is. You can get damages from them for using a mark that's too similar to yours, for confusing people. And so that concept is a little broader because it doesn't have the same rules attached to it that registered marks do. And there's different levels of protection that go to each of these. So if you have a registered mark, you have protection across Canada. If you have an unregistered mark, you only have protection within the region where you have developed goodwill. So if Bianca over at that end of the room has a mark and she thinks that this table over here has infringed her mark, but that end is Halifax and this end is Alberta, if she's got no reputation over here, she can't enforce her mark against you because they don't have a level of protection there. So if you have a level of protection in Calgary, but not Edmonton, then someone else can use basically the same mark as yours in Edmonton and it'll be fine. If you have protection, if you have a province-wide business in Alberta, someone else is using something similar in Ontario, but you don't have a reputation there, then your level of protection won't allow you to go after them if it's unregistered. If it's registered across the country, you can go after them. The other aspect is enforcement. So if you are trying to enforce your mark against someone, having a registered mark gives you a lot of advantages. First of all, the onus shifts from one to the other. If you have a registered mark and someone wants to say you don't have rights in that mark, they have the onus to undermine your mark. They have the onus to say, no, you aren't the one who properly should have registered this mark. I should have registered it, or I had the right to register it, and so you can't, that sort of thing.
You can answer this question, tell me if you can. I have a question about if a company starts, say, in Canada. I know if it's ice cream company in Calgary that they have a name in Canada, then after they grew their business, they decided they wanted to go to the States, and they came across a company in the States that was using the same name for ice cream. And so they opted to change their entire brand and rename their company. Is there anything that you would advise a company doing if they're just starting out to avoid having to do that in the future?
So certainly one of the things to do before you start using a mark is to do a bit of due diligence on, is there someone else in the marketplace that's using a mark that I might be infringing on? Because one of the worst things, and I have to do this every now and then, when someone calls me, they get a cease and desist letter in the mail and they're like, all right, I'm in trouble. Someone's trying to say that I'm infringing their mark. And sometimes they are. And sometimes I have to tell them, look, we got to negotiate a deal. We'll extend the time for you to rebrand, but you have to rebrand your company because you've infringed someone else's mark and you don't have the right to do that. And they're going to succeed if they take you to court. So before you start using a trademark, doing some due diligence, if you go online and you search on Google for Canada trademark search, you'll come up with the trademark database website, and you can just search for names or logos that are registered in the Canadian trademark database. And that allows you to go in and say, okay, I want to use this name. I'm going to go search it. Looks like there's no one else using it, or it looks like there might be someone else using it. And that will allow you to get an idea of what's out there. And then just like a basic Google search is another element, because of course that the search of the database won't show you any unregistered marks. It's only going to show you registered ones. So doing a Google search, seeing, is there anyone else using a similar name in Canada, in Calgary, in Alberta, wherever it is, then that way you're not putting all your marketing effort into building a brand that you might then end up having to give up, because it's an expensive process to have to rebrand your company. It's a lot of lost goodwill.
Is there any pitfall to preemptively registering trademarks in other markets?
Yeah, so you can, well, there really isn't too much of a pitfall to it. If you don't use your mark And obviously this is different market to market. Like I'll talk about Canada's law, but the US is going to have different laws. Europe's going to have different laws. But if you register in one area, you have a level of priority in other areas to register your mark within a specific period of time. I think it's 6 months, although Patrick might be able to tell me otherwise if I'm wrong on that on the trademark front. But if you register in Canada, you have another 6 months or so of priority against someone else registering in a different market. So there's agreements between between countries as to certain trademark rules that are international that allow you to go and take a registration in Canada, and that gives you a presumptive right to register in the States or in European Union countries that are part of these same agreements that we're a part of. So you definitely can do that there. And I'm going to talk in a minute about some of the other elements that you have with a registered mark. But first, let's talk about if you do have someone else who's infringing on your mark and you go to court, what can you get? Usually, trademark cases aren't about damages. You can get damages, and you can get pretty large damages in some circumstances, but usually what you're actually fighting about is the right to use the mark. It's the right to the brand, who has to give it up. So really what you're talking about is more about injunctions or expungement. Expungement refers to if you have a mark registered and someone challenges your mark and say it's not a properly registerable mark because it's too descriptive or generic, or maybe they're saying that I was the one who had the right to register the mark first because I had already developed a reputation in that mark, and so your mark should be expunged because my mark is the proper one. Those are ways that you can expunge someone else's trademark. And usually what you're fighting about is injunctions, which is meaning if you get an injunction from a court saying you can't use mark A, then that means that you can no longer use that mark. And so you have to rebrand your company. You can't use that anymore. Declaratory relief, that just refers to the court basically saying, yes, you are the one with the right to this mark. And transfer website domains, of course, nowadays some of the most expensive and lucrative real estate is online. And so the name of your mark.com, simple.com for instance, or ironwoodconstruction.com, that is the use of a trademark. So if someone else registers ironwoodconstruction.com and you have a registered mark to that name, then you can go to the court and say they're squatting, they're cyber squatting, and they have infringed my trademark by registering this domain name. And so that's another area that a lot of people will fight about in terms of getting back domain names that are infringing to a registered mark. Another part of online enforcement is search engine infringement. So if you do a Google search, you'll have Google searches that will come up that will have certain indications. You'll see a trademark, or like a logo, or you'll see the name of the company, and they'll have a bit of a description. Sometimes you'll have those and they will be on first impression. Again, it's a test of first impression for the casual consumer somewhat in a hurry. If they look at that and they say, they describe their products as being, we sell iron and wood and we're a construction company, and you use a logo that's very similar to Ironwood Construction and they have that registered, then that Google search result, whether it's an advertised one that is paid for or it's an organic one that comes up, that can be infringement in and of itself. And you can go to Google, they've got a report content page. And if you have a registered trademark, this doesn't work with unregistered ones, but if you have a registered one, you can say, hey, take this down. This is infringing on my mark. And Google will actually take that off their search results, so it won't come up. Microsoft, Bing, YouTube, all these other ones have similar sorts of things. If people are infringing online and you can show that you've got a registered mark there, then you have certain avenues to be able to take the search results off. Now, of course, there are border issues when it comes to these sorts of things, but they will take off, say, the results in Canada, that you won't have this come up within Canada as a Google search result, but it might still come up in the States.
Question about that.
Yep.
So like if you show like that you have the registered trademark for it, I feel like Google and Microsoft will say, yeah, that makes sense.
Yep.
But what if it's the unregistered one? You have to prove it to them that like I am in Alberta, like how much evidence do you have to provide?
So the process that Google and Microsoft have is, it's not a court one. It doesn't comply with court rules. So it's just what that company wants to do. If you go to the court and you say, I've got an unregistered trademark and these people are passing themselves off, the court can rule that Google has to remove it from their search results. You probably have to serve Google and bring them in and that sort of thing. So technically they could do that, but the rules that Google actually has set up on their website for reporting only says that they will do it for a registered trademark, not an unregistered one. So it's not a formal process. It's just the process that they've set up as a company, and that's how they've chosen to do it. But there are avenues through court that you can use to get the same sort of thing, but you have to go a longer route to get
I
it.
can imagine that to be tricky if, let's say, the one that's like passing off your brand is like in, I don't know, like Russia, you know, and it's like, how can you serve over there?
Yes, exactly. And the rights that you have, again, are just within the geographic area. They're just within Canada. But I do actually have my next slide. So IP border enforcement. This is if someone is, and I get this with a lot of companies like furniture companies or other companies that are providing products that they ship into the country. So if a Russian company is passing themselves off as yours, they've taken the website domain, it's registered outside of Canada, they've used your mark, but they don't have a presence within Canada, but they're selling physical goods that they need to import into Canada, you can contact IP Border Services and get them to stop these products at the border. So they will search them, they will say, okay, you can't import these, they'll stop them at the border and stop them from bringing them in to be able to prevent that level of infringement. So this is one of the areas where you can protect yourself against foreign infringement. Even if you can't necessarily stop them from presenting themselves as you can stop them from selling into the Canadian market. And as long as they're selling into the Canadian market, there's going to be an avenue through this or through the courts if they're selling goods that are not physical. There'll be a different process through the court that you can use to prevent the service providers from selling their products into Canada. So there's our avenues, but again, for border services, if you're going to do that, you need a registered mark. You can't do it with an unregistered one. For copyrights, you don't actually need it registered, but for those ones you do.
Like this happened to our company where a company or some scammer from China set up a WeChat group and like totally stole our logo and was trying to get people to like, pay them. So look, we just like joined that WeChat group and said this is bogus, and then we put a thing on our website saying this is a scam.
Yeah.
Is that, I don't know what else we could have done.
So there would be options to go through the court, and like there's some method that they have to use to connect with people in Canada, whether it's getting them shut off through the service providers, or it's if it's sold through WeChat. WeChat will have a presence in Canada, and they will have something where you can sue them and get an injunction against WeChat to have it taken down. So as long as there's something that they're selling through that has a process in Canada or a presence in Canada, if it's the social media platform, if it's the it's Rogers or a different sort of IP provider, there will be an element that you can do to go after them, and it just is a question of cost-benefit analysis at that point in time. Is it worthwhile going to get that to going after WeChat to get that injunction? Maybe, maybe not. I don't know what the level of damages are there, but that's one of the options that you can have to do that. And the last one I had here is kind of if you end up on the other end of the stick, if you receive a cease and desist letter. I was trying to come up with some good suggestions to give, but at the end of the day, I just came up with call a lawyer. The bottom line with these is because the cease and desist letter comes before a statement of claim is being filed, there aren't formal rules that go with it. So if someone says in a cease and desist letter, respond to me by X date, you don't necessarily need to respond to them by that date. It's an arbitrary date that they picked. So it's not necessarily something where that is enforceable. And with these, sometimes the right option, and I tell people this a lot when they call in, they get a cease and desist letter, sometimes the right option is just ignore it. It's pretty cheap to send out cease and desist letters. It's pretty expensive to start a statement of claim, comparably speaking. Might cost you, call a lawyer, might cost you $1,000 or $1,500 or something like that to get them up on the file and send out a cease and desist letter. Or if they're sending out multiples, maybe it's $2,000 and they can send out 10. But these are pretty cheap to send out. And so sometimes people will look at it and be like, okay, it's worth sending out the cease and desist, but then you get no response. And the next question is, okay, do I want to start a statement of claim? You tell them, okay, it's going to cost you more like $3 or $4 grand to just do the statement of claim and get it started. And then it will cost you more the longer the litigation goes after that. People will often say, okay, well, it's not worthwhile. So some of it is looking at who is the one who is targeting you with the cease and desist. If it's VW targeting you or RBC or something like that, they're probably not going to be worried about the legal cost of going after you. But if it's a smaller company, if it's a local company that you don't think is going to go forward with anything, then sometimes it's just best to ignore. Sometimes the best option is to negotiate. You can negotiate terms like, okay, we will change our name, but you're going to give us a period of time to do it. Or maybe we will negotiate away the damages that would be dealt, or maybe you just have to fight. It's difficult to say what the right option is in the abstract because there's all kinds of different options here, and each situation is going to be a bit different than the others. So best option when you get that is to call a lawyer, and usually the cease and desist came from a lawyer anyways, and just having a response from a lawyer gives a certain amount of heft that also benefits you in the conversation. So usually it's a fairly cheap process to call a lawyer about a cease and desist and have them communicate with the other side. If things get going, then it gets a little more expensive. So I'll pass it over to Patrick unless anyone else has any questions about the trademark area. Yep. So for filing a trademark, I think it's somewhere around like $3 grand or so as a cost to file. Don't quote me on that. You probably have to talk to Rhiannon. I do the litigation side when things go sideways. But I think it's somewhere in that range to file the trademark. Now, the trademark process, SIPO is really backed up. And so it takes about 3 years or so to actually get it registered. But if you register it and you file the registration and then you have someone who is infringing on your mark or you have a dispute in court, then you can contact SIPO and there is a speed up process where they will basically look at it much sooner. And so that 3 years can go down to a couple months, and you can get that resolved in time to be able to use it for your litigation process. So there are ways to speed that up, but yeah, they're pretty backed up and it takes forever right now. Yeah.
We talked about like trademark a lot. Is it the same as like patents as well?
So Patrick is going to talk about patents. But yes, there's different elements for patents. It's a bit of a different rules, but yes, my talk has been about trademarks, and so I'll pass it over to Patrick then.
To start, I'm going to hand around a piece of paper to each of the tables. Maybe just hand a few to each table and spread them around to your friends, the adjacent tables. All right, so it's going to be up on, a truncated version is going to be up on these screens too, so if you don't have a piece of paper to look at, that's just for your own reference as you discuss this amongst yourselves. So we have a scenario here that is a little more typical than you might imagine. This is continuing on with your construction company example. What we're going to do is walk through these facts very quickly, and then I just want you to take a few minutes and discuss at your table what issues you see potentially arising for you, the owner of your construction company. So you have an employee, they've made some fantastic new tool, you're excited about it, they demonstrated it at a job site, you think, wow, this really does work great. You see dollar signs in your head of spinning off a new company just to sell this thing. But you need somebody to refine the design a little bit. You're not sure it's commercially viable in its current form. So you partner with your buddy's got a design firm for exactly this kind of thing. You partner with him, show him the tool, you give him a prototype. Over the next year, him and his buddies work really hard. They improve it. They make it more commercially viable. And in the meantime, you figure out, okay, this tool has been proven in the field. You're getting a bunch of customers who are excited about it. You're talking about it at trade shows. In the interim, this employee leaves. Employees leave quite frequently. You get the new tool back from your friends at the design firm and you start marketing it. And around that time, you learn that the ex-employee has started his own company and is selling his version of the tool to your potential customers. So take a minute, discuss amongst yourselves. What are some potential problems here? What are some potential issues you see? I should say I've intentionally not given enough information here to have a legal correct answer to any of this. We're going to do some issue spotting. Who wants to volunteer, some problems that they've identified or issues, questions that they would want answered if they decided they need to contact a lawyer?
So I'll just say that this isn't a problem if you have a written
That does solve one of your problems. You are correct. And we'll go into that. So ownership. Who owns this thing? Yeah, it depends. It depends big time. And I did not give enough facts to know. We could make some educated guesses, but it really depends on a number of factors. And Ian has raised the very first thing that an IP lawyer would be asking is, okay, well, do you have IP terms in your employee agreements? Did the employee own this thing when they walked away, or do you? And if you don't, well, then there's a whole bunch of other questions about, what was their job? What were they hired to do? What were they compensated for? Were they hired specifically to invent things, or was this like an accountant that just happened to be really good with tools? There's a whole host of questions. Ownership is a big topic, so we'll talk about that a little bit. Anything else? So the most obvious one here would be patents. This is a utilitarian tool. Patent protection could potentially be an issue here. Did the employee file for a patent after he left? Did the construction company file for a patent before or after the employee left? And timing, when did they file? We haven't talked about this yet, but that's a very important question. And I put something in here intentionally that will give an IP lawyer a heart attack when you first contact them. And we'll talk about that. Exactly. We've got two different versions of the tool here. How much has it changed? What improvements were made? If we go back to that definition of invention, you can get a patent for a new useful machine, manufacture, all these other things, or improvements to there. So, and who made the improvements? The design company. Presumably their employees. Who owns those? Who owns those rights? Depends again. It's like, was there an agreement between these two companies when they embarked on this joint venture? Did they figure out who's going to own IP? The design firm's not an employee, so presumably they cannot have been hired to invent anything as an employee, but there could have been some sort of contract, or everything may be unwritten things. Maybe this happens constantly. I mean, everyone here that's in business knows things are great and don't need to be in writing until it goes wrong, and then we really wish it had been. So those are all very good points, and let's talk about some of those. Typical ownership, IP ownership scenario, and then these come up all the time. Here's something very similar to what we just discussed. And we talked about both of these examples. We included both of these examples in the scenario. So you can have an employee, they develop some new IP, either alone or together with other people, they leave the company. And then there's some sort of dispute over who owns that IP, or there's some question. Two companies jointly developing, maybe, and I have seen this where both companies think they own the patent rights, and it can really cause a headache. So if it's not in writing, then it really is a factual question that you're gonna have to look at a number of factors. If it's in writing, wonderful. Yeah, that makes it much easier. And that is my biggest take. If you took nothing else away from listening to me talk today, what I hope everybody takes away is, like, for God's sake, get it in writing. Get IP terms in your employee agreements when you join forces with another company. Hammer that stuff out at the beginning. How is this going to work? Who owns what? Who has first right to refuse IP rights? Who's going to pay for this? Things like that. Get it all hammered out at the beginning. I mean, I'm glad people don't. We make money off people not doing this, but hey, Ian makes money off people not having strong employee terms. But for your own best interests, please do it. It makes things a lot simpler. Is anyone here that feels like they are familiar with their company's employee agreement terms, and if there's IP terms in them? You don't have to raise your hand, but think about it. What about contractors? Independent contractors have a different set of rules or different default rules for ownership than an employee. It's similar, but an employee, for example, if they were hired to invent, like that's their job. You're an engineer a software engineer at Google, and you invent something for Google, that is what you are being compensated for. Likely, Google is going to own it, even if they didn't have an IP term in their contract. That's, I have to say likely, because it's all fact specific. But again, if it was someone, the janitor is also a software genius, comes up with something, likely that's not what they were hired to do. So, but an independent contractor, the default owner is just going to be who invented it, absent an agreement to the contrary. So agreement to the contrary is the rule. We want to swallow everything. Always have the agreement. So we don't need to go through these slides in detail. These just show some of the default rules. But again, the exception is for patents is what we're really after. An agreement to the contrary. So ownership, which is, yeah, we don't need to go through the details of all of these, but just keep it in mind. Copyright has a particular quirk in Canada called moral rights. If you hire someone to design, say, some artwork for your building, or you're a city, and if you work for a city or a municipality and you have an artist build something, you're always going to want to not just have them signing over their rights, but waiving their moral rights. Moral rights means they can control how it's presented in public. There's a famous case about Canadian geese statues that people put Christmas scarves on or something. Anyway, and then the artist objected to that. He still had his moral rights. He hadn't waived them. Or if you had a statue of somebody very important and a business owned it and put a clown nose on it, the artist, if they hadn't waived their moral rights, they could object to that. So be proactive. Get to these issues early, get express written agreements, make sure they're signed. If your lawyer asks you for an employee contract and they forward it over and there's no signature on it, then that's a problem. Get it signed, keep the signed copies. Include the IP provisions. Talk to myself or my colleague Ian over there is a great person to talk to on employee contracts. Get IP agreements when companies work together. So that's really the main takeaways for the ownership issues. Someone else brought up the question, did they file at all, or when did they file? This is very important for patents and trademarks and industrial designs. There are timing rules for when you can file or when you filed in one country, when can you benefit from those rights filing in another country. To file an initial application for a patent, for example, in Canada and the US, there's this grace period. So from the time that you have publicly disclosed your invention or a company has disclosed their invention to the public, go to a trade show, look at this wonderful thing we've done, here's how it works, it's going to change the world. If that's the first time there's been any sort of non-confidential disclosure to any member of the public, and you've explained enough for somebody to understand what the invention is, how it works, that triggers a 1-year deadline to file a patent application in the US and Canada. But importantly, many other countries do not have that grace period. So immediately you would likely be locked out of like Europe and wide swaths of countries that have no grace period. So and that's why in our example, I said, about a year later, the improved design is done. Because I mean, in the meantime, if it had been proven in the field, it's been used in the field, it's been used in public and in residential areas, maybe for construction, or the employee has left and maybe he's been demonstrating his original tool. So if you talk to someone like me and you say, okay, well, we think we'd like to get a patent application, February of 2023, we went to a trade show and talked about this. Like my heart's going to skip a couple beats. And okay, well, what did you disclose? What exactly did you tell people? Did you give away the secret sauce? Did you hold some things back? Timing is very important. And that's talking about any type of disclosure to a member of the public that's not subject to an NDA. It can be a variety of things in this list. So again, to be proactive, get NDAs. When you're talking about a new technology with anybody, and you don't want that to count as a potential public disclosure, get a non-disclosure agreement. Keep it confidential. And that includes like potential customers, yeah.
Just a quick question on the grace period, the 1-year grace period.
Yep.
Is there an obligation when you're going to file to say that you'd be able to disclose it?
No.
What if you didn't? You just wanted to file because that would give you sort of, most people would just know it's already filed. I'm going to try to claim ownership.
You mean like if you think you may have violated the grace period and you want to file anyway? I mean, you could, but then you wouldn't be able to if it went to court. And this does come up when a lot of these questions, the patent office doesn't check whether or not you went to a trade show. They will look for printed publications, mostly other patent documents, but other things they'll look at like any sort of publication document that the patent examiner can find. But they don't know everything. They're not going to go and scrutinize your business and where did you attend shows or did you have clients over to your business and show them this wonderful thing. But if it goes to court, patent infringement lawsuits can be very expensive, and the other side, when there's a lot of money at stake, they absolutely will be digging into all these details and they'll be asking you questions and discovery and wanting to know and that will frequently, those types of things frequently do become issues. So you could file and you could probably get a patent, but you may not be able to enforce it. So yeah, keep things confidential. Make sure your employees know to keep things confidential. Yes?
Stupid question, but does your NDA have to be drafted by a lawyer or
It's a very good question. That's not. There's no rule that says an NDA has to be drafted by a lawyer. I mean, if you do some Googling, you can probably find some basic forms, but for a particular situation, a lawyer will be able to figure out, take a look at it and see if it's suitable for you. So I would still recommend talking to someone or to a patent agent, patent attorney. But I mean, yeah, you can find some basic forms, I'm sure, from public sources, or a lot of companies already have them. I mean, if you try and talk to a large tech company, if you have a small startup, you've developed a new oil tool, you want to sell it to, large energy company X, they will probably send you an NDA to sign because they don't want you running around and saying, hey, using their confidential information somehow. But if they send that to you, make sure, I would recommend having a lawyer look at it. It may not protect you. It's probably just to protect them. Sometimes it will be a two-way NDA, but not always. So, so I know that's not exactly your question, but yeah, it depends on the situation. And again, yeah, train your employees. Make sure they know that they can't just go around talking about whatever your company is doing, that they need to keep things confidential as well. And train them on that and implement workplace policies for handling confidential information. We talked about trade secrets. Those, you don't file for those, but if you have trade secrets, employees have to know that they need to keep it secret, and they have obligations. And if you do know of some disclosure coming up and you're not sure if it matters or not, or even if you don't think it matters, yeah, talk to your patent agent early in the process. Don't wait till it's been almost a year. Usually I tell people, it's best to have, even if you don't know exactly that you're only going to file in the US or Canada, make sure you get an application on file first. Where are we at for time here? Got a few minutes left. The only point I really want to drive home with developing an IP portfolio, not just patents, trademarks, anything, everything evolves. Your business evolves, your trademarks evolve, your logos evolve, technology evolves in that example we gave with the tool. There are multiple versions of the tool. Your IP portfolio needs to evolve along with it. And there are various things you'll want to consider. We don't have time to go through these individually, but just keep in mind that you got a patent, 10 years ago, that's great. Does it still cover what you're doing today? Does your trademark, if you got a trademark for a particular logo, but it's changed a little bit, does your original trademark registration still protect that? So we want to be regularly assessing these things. Oh, I have these appear out of order, that's fun. So have a process in place, periodically look at your IP, talk to your IP counsel, just make sure that your IP portfolio is keeping up with your business. I think we'll skip over these in the interest of time, just some various factors to consider if you want to, when you're evaluating whether or not it's worth filing a trademark registration. For inventions, again, similar things, budget, what are your competitors doing, what do we want to protect? Discoverability means, can somebody figure out what our invention is? Can it be reverse engineered? Usually the answer is yes. Even some complex software models can be reverse engineered. There's some very advanced ways of reverse engineering, but sometimes not. Sometimes it's better just to keep it a secret. Can it be enforced? Even if you do get a patent, can you enforce it against someone? Can you discover that your competitors are even infringing it in the first place? How would you know? Where are your competitors located? Do you need rights in all these countries or what? So there's various questions to figure out, is it worth filing a patent application? We had a few slides on artificial intelligence and where IP intersects with artificial intelligence, but I think in the interest of time, I would like to move on to questions. But the basic idea here is that AI is rapidly spreading into every industry. There are multiple intersections of IP with AI, both in who owns the AI for the, say a machine learning algorithm itself. There's core AI, like the actual models, who's developing that. There's applications of AI, who owns the rights to those. Can you patent an application of a particular model versus the model itself? The data that goes into train models, who owns the data? Do I have rights to that? And content that's generated, by using that data, are you infringing someone's copyright or their trademark? By generating AI content, is the model potentially, are the results potentially infringing someone's IP? So there's really there's multiple ways that AI and IP intersect. And we could talk about that alone for the whole session, but we don't have time to do that. But if you have any questions, feel free to talk to me after. I mean, I'm around, happy to answer questions. That's why I'm here. So yeah, we're about out of time. So does anybody have questions?
Yeah, I have a question.
Yeah.
To say your scenario here, this tool.
Yeah.
Is there a standard for how much change needs to happen before the patent is no longer applicable? Is it a 40% change of the design?
There's not a standard like that, but the question is there's really two questions. There's how much does it have to change to be a subject, like how much of an improvement does it have to be for a new patent to be able to be granted for the improvement? And that is just anything that's not obvious. If it's new, useful, not obvious, and that just means inventive. And it can be a small invention, any sort of surprising benefit or improvement anything that wouldn't be obvious to a skilled person in the art. That's sort of a mixed question of law and fact. And that's a really wishy-washy answer, I know. The flip side of that is for infringement. How different does your product have to be to not infringe someone else's patent? So a patent has claims at the end, and they set out exactly what, they set the fence around what a patent protects. There's a number of numbered claims at the end. So if you see on the news, Microsoft gets patent for, turning on a computer. You see and then everyone gets enraged. Like, what? People have been turning on computers for years. But if you look at the claims at the end, that's going to set what are they actually protecting here. And it's going to be very narrow, much narrower than some broad concept like turning on a computer. So you look at these claims, for a mechanical structure, it's going to set out a specific structure, like some various elements, how they connect it or how they cooperate. And those claims set the fence. So to infringe a patent, somebody has to practice every one of those features. Like, so in a given claim, say claim 1, it'll have a number of elements. Someone has to practice all of those elements. If there is any element that's still considered essential, it's not omittable, and the competitor is not doing that piece of the claim, then it's not infringement. And to infringe a patent, you have to infringe any one claim of the patent. So how much you can vary really depends on what is in those claims and what elements do they set out and what would be considered essential or non-essential. Non-essential ones can be varied a little bit, and that's a whole other discussion we could talk about for hours, but everyone would go to sleep. So. Any other questions? Yeah.
So, a lot of wishy-washy. Seems like a whole bunch of gray to all of these areas. So,
Yes.
Copyright, trademark, whatever it is. So, just explain for sure my benefit, but maybe everybody's benefit that could potentially be in the same position. Where's the incentive for how much we could spend to say with the lawyers to stop somebody else from using that? The ROI on that investment to stop. Where would we benefit by chasing that, and how much money we would spend versus what we receive back in order for them to stop? Like, it's so great. There's no attachment to a value that would explain to us if we should do that or not.
Yeah, that's a great question. And I mean, when I say gray, it's really a whole spectrum. I mean, there are fact scenarios where, like, okay, you have a strong case. Fact scenarios where you maybe not such a strong case, or like this is just not worth pursuing. So you're looking at how strong of a case do we have. You're also looking at, well, how much damage is the business actually suffering from this? I mean, it could be very negligible, but it could be hundreds of millions or billions. Like it could be a ton of money depending on how big your business is, what your market share is. If somebody else is out there running around stealing your market share, I mean, it's fact. It's different for every situation, but it could be financially crippling. So you really have to go after these things. And so you have to talk to a lawyer. Yeah, you'd want to look, like, how much is it going to cost for the various steps of litigation along the way? Like a cease and desist letter, cheap, full-blown patent litigation. I mean, yeah, now you're looking at potentially 7 figures. So how important is this? What steps what is our budget? How far are we willing to push this? And how important is it to our bottom line? Sometimes it is absolutely critical to try and enforce these things.
Each of the areas is going to be a bit different. Like you say, there is a lot of gray area. One of the things of doing things proactively is it can be a lot cheaper if you have like a good employment agreement to deal with some of these things, or if you register the trademark instead of having to litigate on an unregistered trademark, those sorts of things. So you can make things cheaper by being proactive on it. But when you're thinking about the value, think about, like, how much money do you put into building up your brand? How much money does your company put into marketing? If it's worth $1 million marketing budget to build up this brand, then what is it worth to be able to protect the brand that you've built up? And when you're talking about brands that you've built up, even if it's not advertising, maybe it's just going to these conferences and building up that brand recognition by meeting people at conferences and talking to them and doing work for people. And you built up that for 10 years or 15 years. What is the value to your business of losing that brand, having to rebrand, or losing the rights to that, or having someone else trade off of your rights. So it is a bit gray in terms of the fact that these are concepts that you can't put as clear a value on as, well, this piece of equipment is worth X dollars, but it is so much more scalable than hard assets. If you're talking about the most valuable piece of equipment in the world, that's probably ones that are, millions of dollars. But if you're talking about the most valuable brands in the world, I think Apple's brand was valued at $880 billion.
Right, but we're talking very large businesses, right? So
Yeah.
I'm just saying,
Yeah.
So it sounds like I understand the value of what we all create. So it's more of a defense mechanism to stop others. But then when you go after those others, how much does it cost and how much you're going to return or get back for spending that money? So if you're a large company, I think it was said earlier, it's not going to be a big deal for somebody to rip off a 7-figure amount to stop somebody else from doing that. We were just talking, saying it's almost worth it for the ones who are infringing, because what do they have to give up to piggyback on the large? Maybe they get a cease and desist. What can they go after you for? That's something that's recommended. I'm just saying that it seems like that the better part of it is not on the ones who have to go after somebody.
And sometimes the right answer is, you're in this situation, you're trying to figure out, is it worthwhile litigating this? Talk to a lawyer. Like, a lawyer can probably answer that question for you, give them the fact scenario, and can probably answer that question for you in a 15 or 20-minute phone call. And that'll give you the direction of where you want to go. And I'll give you an idea. This is how expensive it's likely to be. With litigation, it is still, it takes two to tango sort of thing. If you settle the case on day one of the file, then it's going to be a lot cheaper than if you have to go all the way through trial. But if you talk to the lawyer, if you have a conversation with me, I can give you a pretty good sense of what it's going to cost to do each part of this, to go this far down the road. And then you can go and talk about it internally and decide, is this worth going forward with? And usually it's pretty cheap to have a 20-minute phone call with a lawyer and a couple $100 or whatever, and have that conversation and decide, is it worth going ahead with the next steps?
Yeah, but I know we're out of time. I just wanted to also point out, the value of IP isn't just in enforcing it against others. It's in, again, leverage. When you talk to a company, well, what do you actually own? Why do I have to talk to you? Why can't I just do it on my own? And it can also be licensed if you are, and this happens all the time where two companies are in the same field. They have different patents. One asserts a patent against another, and they realize, okay, most things don't go to court. Most things get settled out of court, and maybe they come up with some sort of cross-licensing agreement where they're each licensing their technology to each other because people want to be able to coexist. Maybe they're not interested in necessarily wiping each other out. They're going after different customer bases. So there's a whole range of value and uses of IP, aside from only going after people in court. As if a small company wants to sell their company to someone bigger, the bigger company is going to they're going to do their due diligence on what IP do you own and what should I be paying for.